All right, let's get into it. Today, we are talking about one single court case from 1998 that, and I'm not exaggerating, completely changed how we think about contracts. And this isn't about some dusty old law books. Oh no, this is all about what words really mean when the stakes are incredibly high.
I mean, really think about that for a second. When you sign on the dotted line, is the meaning of that deal just stuck to the exact words on the page? Or is there something more going on? For, centuries, the answer to that was pretty cut and dry. But then, this one case came along and asked that very question, and the answer it gave was a total game changer.
So, let's dive right in. Look, we've all been there. Communication is messy, right? We misunderstand texts and emails all the time because, the words themselves don't tell the whole story. Well, it turns out contracts are exactly the same.
This right here, this is the perfect way to think about a huge legal problem. Imagine you ask your boss for a super urgent decision, and they text back, "Okay, see you later." That feels, it feels pretty different from a friend texting you the exact same thing to end a casual chat, right? The words are identical, but the context, who sent it, why they sent it, what was going on, it changes absolutely everything. And that's the exact puzzle courts were facing with massive, multi-million-dollar contracts.
Now, before this big landmark case, the legal system had a super strict way of handling all this. It was a philosophy called literalism, but you can just think of it as the dictionary approach. And you can see the big clash right here on this slide. The old way was just simple. You open up a dictionary, you find the word, and boom, that's what it means. End of discussion. It didn't matter what the people signing the contract were actually trying to do. The modern way, the one we're building up to, it just flips that whole idea right on its head.
So under this old rule of literalism, if you made a typo and wrote buy instead of sell in one little clause, a court could actually force you to buy something, even if the other 49 pages of the contract made it blindingly obvious that you meant to sell. It was all about the grammar, not the real-world business sense of the deal.
As you can imagine, this super rigid approach was causing some huge problems. It was leading to results that were just commercially ridiculous. And the breaking point, the moment it all came to a head, was in the late 1990s with a case called Investors' Compensation Scheme versus West Bromwich Building Society.
So the backstory here is that a bunch of investors lost a ton of money because of some really bad financial advice. The legal forms for getting compensation, they were a total mess. If you read them literally, they just didn't make any sense at all. This whole fiasco ended up in the UK's highest court, where a judge named Lord Hoffman decided, you know what? It's time to change the rules.
And this is where it gets really interesting. Instead of just fixing this one messy document, Lord Hoffman laid out 5 new common-sense principles for how to read all contracts. This was going to be the new rulebook for every court. This was the moment it all changed.
This sentence, this is the heart of the entire revolution. Forget the dictionary. The new test is this. What would a normal, reasonable person think this contract means if they knew everything the two parties knew when they signed it? It's a huge shift from just looking at words to actually understanding the intent.
So these are the 5 big ones, the 5 principles that completely change the game. Let's just, walk through each one so we know what we're talking about.
Okay, first up, the meaning has to be objective. The court isn't trying to be a mind reader. It's not about what you secretly wanted the contract to mean. Instead, the court puts on the hat of a neutral, informed observer and asks, what would this person conclude? This was a massive step towards making contract outcomes way more predictable and, frankly, more fair.
Now, this next one is my favorite part, the matrix of fact. What a great phrase, right? It basically means the court can look at, everything. The whole commercial purpose of the deal, what the market was doing, the history between the two companies, absolutely anything that was in the air at the time. It's the legal version of looking at the whole text conversation, not just that one case.
Of course, you've got to draw the line somewhere, and that's what Principle 3 does. The law says you can't bring in all the back-and-forth emails and draft documents from before the final contract was signed. And the reason for that is really practical. It just stops endless arguments about he said, she said. The final signed contract, that's what counts.
And this one. This is the one that really takes a sledgehammer to that old dictionary rule. It says that the meaning of a word isn't set in stone. It's shaped by the context of the deal it's in. So let's say everyone involved in a deal agreed that for their purposes, the word apples actually meant oranges. Well, guess what? A court will enforce it as oranges. Context can literally rewrite the dictionary for that one specific agreement. How cool is that?
And finally, we have the common sense safety net. This principle just admits that, hey,
people make mistakes. If reading the words exactly as they're written leads to a result that is so crazy that no sane business person would have ever agreed to it, the court can now step in and say, whoa, hang on a second, this is obviously a mistake, and then read the contract in a way that actually makes sense.
So you put all 5 of those principles together, and what you get is what everyone now calls the common sense revolution in contract law. It was a massive shift away from those strict academic rules towards what real people are actually trying to achieve in the real world.
And that's what we call it today, the contextual approach. It's the philosophy that rules the day, and it all goes back to Lord Hoffman's decision in that one case. I mean, he didn't just settle a dispute, he completely rewrote the operating system for how contract law works.
So why should you care about any of this? Well, because it means that any agreement you sign is now much more likely to be understood in a way that actually makes sense for your business. It protects you from somebody trying to take advantage of a simple typo, and it makes sure that the spirit of your deal is just as important as the letter of the law. It puts common sense right where it belongs, at the heart of the law.
And that really just leaves us with one final thought. The next time you're reading a contract, or even just a simple agreement, try to think beyond the words on the page. Ask yourself, what's the bigger picture here? What's the matrix of fact surrounding this whole deal? Because in the eyes of modern law, that context, well, it's everything.